Okay, we're going to go ahead and get started, if we can. We appreciate everybody coming today, and I know it's a very, very busy time of year, so thank you all. We were hoping if we did it in early November, that was better than December. When we were here a few months ago doing our last program, we did sort of a potpourri program about, just various topics, and that seemed to go over well. So we decided we would do something similar this time, which is basically the, 10 or so failures that we see in estate planning and how to correct them. And they run the gamut from tax issues to simple little things. And we hope that at least one or two of these different items will be something that you will find interesting. We are all going to speak, all of us. I'm sure this isn't the first time. Is this the first time for anybody here? Welcome. Great. Thank you all for coming. Super. Well, then in that case, I'm Lauren Detzel. This is Brian Malec, David Akins, and Matt Ahearn. I was going to say you all know us. But I do want to introduce a couple of other people that are here from Dean Mead. We are very fortunate to have with us a new associate that we hired in our estate planning department, Kyle Griffin. Kyle is over here. Kyle is a triple gator and getting his undergraduate JD and his LLM degree from the University of Florida. I was fortunate to have him as one of my students. And after he graduated, he went up to Boston and worked at one of the big four accounting firms for a year. And I think last year's winter in Boston pretty much did him in, a Florida boy in Boston. And he said, I don't think so. I need to get back to Florida. So we're happy he joined us last month. And I know we're all looking forward to you all getting to know him well. And we also have Alex Van Hyde here somewhere. I saw him. There's Alex over there in our real estate department, and he does a lot of work with all of our estate planning clients. So thank you, Alex, for coming. And I'd like to just do one other little brag thing, if I can, and that is I know that a lot of you know that I have been a member of something called the American College of Trust and Estate Counsel for many, many, many years. And it is a wonderful organization, and I'm really thrilled to be able to say that my dear partner, David Akins, was just elected a new fellow in ACTEC. So yay, David. Okay. Enough of that stuff. So we'll get to the good stuff. And we're going to talk about things that are done wrong in the estate planning world. Oh, and I just saw another one of our people come in. Ed Waters just joined us. Ed's walking down. Thank you, Ed. He's in our tax department also. Another one of my former students. And so we I characterize everything that we're going to talk today in two different areas, either a failure to follow through or a failure to think it through. And so we're going to talk about things that are in both of those categories. A lot of times what happens in estate planning is just a failure to follow through. We've all heard the adage, the devil's in the details. I've probably said it a million times without exaggeration in my career because it is very true, especially in the estate planning world. You can put together the greatest plan and you don't follow through with all of the rest of the details and your whole plan falls apart. And so just a few items, a lot of us are going to be talking about this the rest of the day, but just a few items are if you make the mistake of creating a revocable trust and not funding it, because after all, one of the main reasons that we create a revocable trust is keep assets out of probate. And if you don't transfer that ownership of the assets into the revocable trust during lifetime, then you don't avoid the court process and the consequences that you have to go through probate. And if you have real estate owned in another state, then you not only have to do a probate in Florida, you got to do a probate in the other state where the real estate is located as well. Major fail. That is one of the biggest problems that we see. Another huge problem that we see is failure to complete or update beneficiary designations. And with the consequence being that we have beneficiaries get assets that we didn't want to have. Either it may go outright instead of in a trust, or it may go to X instead of Y. And we can even lose the creditor protection. A really simple example is something happened a number of years ago. I had some children come in to see me, grown children come in to see me. Their parents had not been clients of mine, unfortunately. Their parents had died together in a plane crash, and just before the plane crash, their father was going through really bad business reversals and was looking at doing bankruptcy, had not filed yet, had a lot of life insurance, and the life insurance was payable to the surviving spouse, and there was no contingent beneficiary. So the surviving spouse dies with the insured, and where did all of the money end up? In the probate estate. And so every single dime went to the creditors, and not any of it went to the children. And had they simply designated a contingent beneficiary, being the children or a trust for the children, they would have gotten the insurance instead of the creditors. So failing to correctly do beneficiary designations can have unfortunate consequences, to say the least. Not making payments on intrafamily notes. A lot of due to froms in between individuals. We make a lot of loans to family members in lieu of making gifts, and because the interest rates are very low, extremely important to actually make payments on those notes, because what can happen if you don't make payments is that the original loan is going to be reclassified as a gift. I'm sure we've all seen clients who say, I'll just make a loan to my child of $100,000, and then we will excuse that or give away the annual exclusion amount every year, and so we won't have to we will forgive that against the loan, so we won't have to use any of our lifetime exclusion. Well, if you don't actually make payments of interest and principal, it's very likely the IRS is going to reclassify that all as a gift at the time that the loan was made instead of a loan. And it can be even really bad, much worse, if you had an installment sale to a grantor trust and you don't make payments. Then you could end up with all those assets that were sold that you think are out of the estate back in the estate and subject to estate tax at what is probably a higher value at that point in time. Failing to respect entity formalities, like when we create LLCs and partnerships and we don't correctly title the assets into the name of the entity, we don't change the insurance, we commingle assets, we pay personal expenses out of the business accounts, all of those things can end up with losing the creditor protection of that entity, either from inside creditors or outside creditors. You don't want to do that. We're going to talk later about disregarding obligations as trustee, with the consequence being personal liability of the trustees. And not filing gift tax returns can mean that you can end up with the IRS assessing gift tax interest and penalties at a later date, and a lot of confusion over how much exemption is actually left. And the last one in this area is failing to confirm that how an account is owned. If you're trying to have an account owned as tenants by the entireties, and it is highly likely that it could end up actually being treated as owned joint tenancy with right of survivorship if you're not careful. And of course, there's a big difference in that. If you have a creditor, as we know, a creditor of just one spouse cannot get any part of a tenants by the entirety account, whereas they can get half of the account if it is a joint tenancy with right of survivorship account. And just a quick reference to a fairly recent case. Let me start with, we have a presumption in Florida. 655.79 is a presumption that says, with respect to a bank account or a CD, that if it's in the name of two persons who are husband and wife, it's going to be presumed to be a tenancy by the entireties. But the important part is, unless it's otherwise specified in writing or unless provided in the signature card or the agreement. And there are a lot of banks in Florida that don't offer tenants by the entirety accounts. You think it might be a tenants by the entirety account. You said you wanted a tenants by the entirety account, but then you read the fine print of the account agreement. I see Alex nodding his head. You read the fine print and it says, and under no circumstances can a tenancy by the entirety account be created hereunder. Okay, and so the little tiny fine print, even though you thought that's what you were doing, means that you don't have a tenants by the entirety account. And a recent case, the Wexler case, here the owners thought that they were getting tenants by the entirety accounts. That's what they thought they were doing, but the actual bank officer, without really explaining it, selected the option in the fine print on the account that said joint tenancy with right of survivorship, not tenancy by the entireties. And the court says account owners are deemed to know what they sign. Okay, so if some bank officer checked a box that said joint tenancy with right of survivorship, even though you said tenants by the entireties, too bad. Okay, so read the fine print. Okay, mistake number 2 is failing to plan for the elective share. So I said everything is either failing to follow through or failing to think it through. This is one of those failing to think it through things. All right, just a little tiny bit of history about the elective share. From time immemorial, there has been the thought that an individual can leave their assets to anybody they want to leave it to, with the exception of the fact that you can't disqualify, you cannot disinherit a spouse. Okay? And that is true, has been true, and isn't true in almost all the states, not all of them, but in almost all of the states. And over the years, it has taken the form of a lot of different things. In Florida, it used to be dower and curtsy. Some of you may remember that. Then it became the elective share. And it was until modern times, just the last 20 years or so, the way they always did a determination of what the spouse was entitled to had reference to the probate estate. Okay? And it was, for example, in Florida, 30% of the probate estate. And unfortunately, with the advent of the revocable trust, it became very easy to disinherit a spouse. You just put all the assets in a revocable trust or joint with somebody else, and there was no probate estate. Therefore, there was no elective share. Very famous case in the 90s dealing with the then owner of the Miami Dolphins, Joe Roby. The Florida Supreme Court said this is really in which Mr. Roby completely disinherited his spouse of like 40 years by putting assets in a revocable trust. And the Florida Supreme Court said, we really wish we could do something about it because that's really against the public policy, but we can't because that's what the statute is. But legislature, if you don't change it, the next time this is in front of us, we will change it ourselves, and you won't like it. And so a number of us spent years of our life in the 90s working on the elective share statute, which was changed effective in 2000. And it then includes assets that a decedent owns in a revocable trust or in a joint account, etc. And in addition, we have something in Florida, as we all know, Homestead, which protects assets against creditors. It also protects the house, the primary residence, from being taken away from the spouse and the kids. And so back in the 1800s, in the Constitution, they said if an individual owns a house themselves and they're survived by a spouse and children, lineal descendants, then they can't give it somewhere else. It has to go a life estate to the surviving spouse and remainder interest to the children. We have that law today, except that a couple of years ago we added something because in the context of second spouses and children from prior marriages, owning these houses, life estates, and remainder interest was kind of yucky. And so we came up with this provision that says that a surviving spouse can make an election to have the house treated as owned 50-50 in tenancy in common with lineal descendants, and then it's eligible for partition, and the house can be sold, and they divide up the proceeds 50-50, and it doesn't matter about how old they are, whether they're 90 years old or 50 years old. It's just a flat 50-50 kind of election. And so let me give you an example of how all of this works together. So assume husband dies first and is survived by his second wife and 2 children from his first marriage. There's no prenup, and he has a will that says I leave everything to my kids. And let's assume the wife makes that elective share election and also makes that election to take 50% of the house instead of a life estate. So we're making this really easy and very common. We've got a decedent husband owned a brokerage account at $2 million in it and a primary residence that was worth $1.5 million. So his total assets are $3.5 million. The question is, what does the wife get and what do the kids get? Well, it makes a big difference here whether that house is owned in the husband's name alone, which falls in that protected homestead class that we talked about a second ago, or whether it's owned tenants by the entireties, which is an exception to homestead. So that rule about life estate to the spouse, remainder interest to the kids doesn't apply if the house is owned tenants by the entireties. The surviving spouse gets it automatically. Makes a big difference as to what the spouse gets if it's owned one way or the other. So if the house, the protected homestead, is owned solely by the husband, the elective estate is just $2 million because the homestead doesn't come into the calculation of the elective estate. It's separate from the elective estate. Unlike if it is owned as a joint asset, then like all other joint assets, half of it comes into the elective estate. So here we have the elective estate is $600,000. And the wife gets the $600,000 elective share, and then she also gets half of the house, which is $750,000, and so the total is $1,350,000. And the kids get the rest, so they get the brokerage account minus what they had to pay for the elective share, $600,000, and they get $2,150,000. Okay, so now look what happens if the house is owned tenants by the entireties. So here, now it's not protected homestead, so it comes into the elective estate, half of it comes in. That means now the elective share is $825,000, but because the way the elective share works is if the spouse receives assets either through joint ownership or by a beneficiary designation, then those assets are counted towards satisfying the elective share. So here, the surviving spouse got half of the house. Okay, so that counts towards the $825,000 elective share, and so now the remaining elective share is only $75,000. So what does she get? She gets all of the house because it was owned tenants by the entireties, so she gets the whole thing, and now the elective share is $75,000, and so she gets $1,575,000, and the kids get $1,925,000. There's a $225,000 difference just based upon whether that house was owned in the husband's name alone or in tenants by the entireties. Okay. Now let's add life insurance in on that. Okay. And one of the things, and this was actually known for years as the Detzel clause, because I was on this committee, I spent a long time drafting this, and I said we absolutely have to have an exception for life insurance. And so the way the elective share works is that life insurance is not included, the proceeds of life insurance is not included in the elective estate. The only thing that's included in determining the 30% is the cash surrender value. And so this is, because I represent a lot of closely held business owners, this was a way for them to have life insurance to satisfy the elective share and be able to leave the closely held business interest to the family. So they could buy a life insurance policy and fund the elective share with that. Okay, so now in our example, we say husband knows all about that. That's great, super. I want my kids to get more. I'm going to go get a life insurance policy. He does that. It's $600,000 death benefit, and he names the wife as the beneficiary. What happens? Okay, so without going through in the interest of time all the calculations, I'm sorry, I already said that the life insurance is not included in the elective estate because here there's no cash surrender value because it was a term policy. But the other thing is that, which makes this work, is that if the spouse receives proceeds, okay, just like she receives anything else, that counts towards satisfying the elective share. Okay. So here now we have $4.1 million of assets when the husband dies, and who gets it? Well, if the house was owned solely by the husband, okay, there's no difference here from the first example we did because the life insurance is not included in the elective estate, and the spouse gets $600,000 of life insurance instead of getting the elective share, so that washes out. And the surviving spouse still gets $1,350,000, and the kids get the extra $600,000, just exactly what husband wanted to have happen. Okay, we used the life insurance to satisfy the elective share, and the kids got the extra $600,000. that was their interest was being diluted by giving that to the spouse. But oops, what if the house was owned tenants by the entireties? Okay, big problem. Now you have half of the house is included in determining the elective estate, like it was before. Still the same elective estate. The elective share is $825,000, but because the spouse is the beneficiary, okay, of the insurance, we have both the house and the life insurance used to satisfy the elective share, and that means now the wife gets the house because it's tenants by the entireties. The elective share is zero, but she got the life insurance. So now she got $2,100,000. What did the kids get? $2 million. All they got was $75,000 more because that was the amount that was actually being diluted to pay the elective share in the prior example. So that didn't work at all. Okay, what went wrong? What went wrong is that he designated the spouse as the beneficiary of the insurance. If instead, okay, the husband had made the estate or the kids the beneficiary of the life insurance, then I'm going to just jump to the end, then that means that if the house was owned solely by the husband, we have the same result, okay? We won there. The kids got more. And we fixed the problem that occurred if the house was owned tenants by the entireties because now the insurance didn't go to the wife, and the kids got $2,525,000 and the wife got $1,575,000. So $525,000 of the insurance went to the wife, which is what they were trying to do. So what I'm showing here is that just a little bit of knowledge about how the elective share works, okay, is really necessary in any circumstance where we think that the elective share could be elected, because just two little things: how you owned the house, whether you owned it as joint or whether it was a homestead, made a big difference, and how you had the life insurance payable made another huge difference. So those two things can make a difference in this case of over $600,000 of who got what. Okay? And the last thing, okay, I have like 2 minutes left. The last thing that I wanted to talk about is failing to satisfy the adequate disclosure requirements when you file an estate or a gift tax return. So we all know that the IRS has 3 years to audit a gift tax return, or 6 years if there was a substantial omission from that gift tax return, which is they left off 25% of the value. And we know that there's no statute of limitations if you don't file a return. What a lot of people don't realize is that there is no statute of limitations even if you file a return and you do not adequately disclose the gift on the tax return. So in any case where we have assets that are difficult to value, we've got an interest in a closely held business, we're taking a discount, we have real estate. Anytime you have something other than just readily valuable assets, you need to make sure that you satisfy the adequate disclosure rules, or it is as though you didn't even file the gift tax return. And the IRS can come in at any time and even at death and relook at that gift tax return and assess additional gift tax penalties, interest, etc. And so here I tell you what the requirements for adequate disclosure are, and the most important part of that is that you have a qualified appraisal and from a qualified appraiser. If you're not going to do that, you've got to at least have a very detailed description of the method used to determine fair market value, including financial data and any restrictions that are included in like the operating agreement that give rise to those discounts. So, and the problem about adequate disclosure is compounded when we have non-gifts, but that might be gifts. Okay? So, for example, we do a sale to an intentionally defective grantor trust. We take back a note. We hope that we sold it for full value. Okay? We gave assets that we took a discount on and thought it was worth $2 million. We took a note back for $2 million, so there's no gift. Okay? You normally would not file a gift tax return, right? But the IRS might come in and say, wait a minute, we disagree with that value, and those assets were really worth $3 million, so you made this implied gift of $1 million, and you didn't disclose it, and so we can raise that at any time, even after death. So what do you do to cut that off? So you do, and actually you do a disclosure of those non-gift transfers. So when we do sales, we file a gift tax return that discloses the sale transaction. As long as you adequately disclose that, then that starts the statute of limitations running on that non-gift transfer that could possibly have a gift element implied in it. And last thing is that there was a chief counsel memo that came out in March talking about this adequate disclosure rule, and here the taxpayer filed a gift tax return reporting gifts of limited partnership interest, and the limited partnership owned real estate. And what they did was they had an appraisal of the real estate done, but not an appraisal of the entity. And they took discounts, okay? And they said the value of the interest in the entity was discounted for lack of marketability, et cetera, which they did not describe. They did not have an appraisal other than the appraisal of the real estate. And the IRS said no adequate disclosure. Again, it's as though you didn't even bother to file the return. And they can come back at any time and reassess gift tax. So now I'm turning it over to Matt, who's going to talk about more failure to do things.
Yeah, thank you, Lauren. In my portion of the presentation, we're going to talk about common mistakes in trust administrations. We'll move to some common mistakes in planning with IRAs and finish up with a few common mistakes in dealing with homesteads. I've asked David here to manage the clicker for me, and David is following me, so if I run over my time, he may just skip right to the end.
I feel like Vanna White.
Yes. So with respect to trust administrations, I see the mistakes happen most often with non-professional trustees, and I think that the reason is that non-professional trustees often fail to appreciate and understand their fiduciary duties and the liabilities that go along with those fiduciary duties. This causes them to fail to follow or adhere to the appropriate standard of care and take the necessary steps to reduce their liability. And this comes most commonly in handling trust investments and in transactions involving conflicts of interest. With respect to trust investments, the trustees simply fail to follow the prudent investor rules. And the prudent investor rules simply provide that the trustee has a duty to invest as a prudent investor would. And most importantly, this is a test of conduct, not of performance. So it's about the process of investing and not the results. It's also, the standard is an objective standard. It's not what the trustee thinks is a prudent investment. It is an objective standard that would be applied by the court. And the prudent investor rule is based on modern portfolio theory. So you can see on the slide above that, you know, when testing the standards, they're going to look at the entire portfolio as a whole. They're not going to look at one particular investment in isolation, and they're going to determine whether the investment portfolio is appropriate given the circumstances involving the trust. And there's also, under modern portfolio, we have a duty to diversify the investments. What's important and often missed or not done timely is for the trustee to step in and look at the investments within a reasonable period of time after accepting the trust, and thereafter develop an investment plan. And you can see the elements of the investment plan on the slide. Two key points here. Number one, the investment plan has to be appropriate for the purposes of the trust. Obviously, if we're dealing with a marital trust that requires distribution to a spouse, that's a much different situation than, say, a grandchildren's education trust that doesn't have any mandatory distributions and may not be making distributions for a number of years. And in addition, it's important for the trustee to review the investment plan periodically to make sure it is still appropriate for the purposes of the trust. Now, it is possible for the trustee to rely on the terms of the trust, but I would exercise caution here. If there are specific instructions in the trust concerning investment, then those should be followed unless modified by a court. If there are legacy assets that the trustee is managing, such as closely held business interests, and that's permitted, then that's fine. But I would be cautious about relying on boilerplate language which waives the prudent investor rule when you're dealing with a portfolio of marketable securities. Much better idea to continue to adhere to the prudent investor rules in that circumstance. Now, if the trustee is not an investment professional, then it is a very good idea to go ahead and hire an accredited professional investment manager. The trustee is able to rely on the advice of a professional, provided the trustee follows a reasonable process in selecting the advisor, meeting with the advisor, and following the advisor's advice. And I think an often overlooked option here for the trustees is to delegate the duties and responsibilities to a professional advisor. In this case, the Florida statutes would provide that you could shift the duty and the liability for the investments to the professional advisor, provided that the proper procedures are followed to select the advisor, set the scope and terms of the delegation, and periodically review the investment advisor's actions. And one thing here that, again, is often overlooked in this context is giving the beneficiaries notice of the delegation. So that's often not done. Delegating can be a very good idea, but you follow the proper procedures and provide notice to the beneficiaries. Other ways to deal with trustees' liability for handling investments is to either get court approval or beneficiaries' consent, and that may come up in certain specialized situations. But importantly, it should be standard operating procedure for trustees to prepare accountings and distribute those accountings to the trust beneficiaries to begin the statute of limitations period running, and we'll cover that more thoroughly in just a minute. With respect to conflicts of interest, I think this comes up most often when the trustees are also beneficiaries of the trust. They enter into transactions on which they stand on both sides, and that is inherent conflict of interest. I think the trustees misunderstand the standard here. It's not whether or not the transaction is fair to the trust. It is whether or not a conflict of interest exists. And if there is a conflict in a transaction, that transaction is voidable per se. In addition, with respect to transactions with certain related parties that are set forth in the slide, there is a presumed conflict of interest. That conflict can be rebutted, but again, it has to be rebutted that no conflict exists, not the transaction was fair to the trust. So in addition to voiding the transaction, the remedies that are available include monetary damages against the trustee, as well as removal of the trustee. So what should the trustee do in conflicts of interest situations? Well, before the first the trust document should be read to determine whether or not the transaction has been authorized by the terms of the trust. Assuming that it has not been authorized, then before the transaction occurs, the trustee should seek either court approval or obtain beneficiary consents to the transaction. If the transaction has already occurred, the beneficiaries can ratify the transaction, and again, it should be standard operating procedure for trustees to prepare accountings, and the transaction should be adequately disclosed in the accounting that is provided to the beneficiaries to start the statute of limitations period running, and we'll touch on that a little bit more in a minute. So before getting to the accountings more, another failure that we see often is the trustees fail to give notice to the qualified beneficiaries upon acceptance of the trust. This is not only a failure of the duty of the trustee to notify the qualified beneficiaries, but it is also a missed opportunity. When you notify the qualified beneficiaries, you can get a statute of limitations period running for any action contesting the revocable trust, and you can also ask for such things as waiver of future trust accountings and get releases from having to investigate the acts of prior trustees. So this is an opportunity that is often missed by trustees. Now, trust accountings are required to be provided to the beneficiaries unless they are waived. The elements of the trust accounting are set forth in the slide. There is no form accounting for trusts in the statute. So in our office, what we've done is we've taken the probate trust accounting form and we've adapted it for trust accounting so that we are sure that we meet all of the criteria for valid trust accountings. Now, even if a beneficiary waives the right to have trust accountings, and so that duty is removed from the trustee, it is still important for the trustee to provide an informal trust accounting or a trust disclosure document in order to get a limitations period running with respect to matters that are adequately disclosed in that trust accounting. In addition, with respect to trustees who may be ceasing to serve as trustee, they may want to go to court in order to have the court approve the final accounting of the trustee so that their liability ceases at the same time that they cease to serve as trustee, as opposed to having the limitations period extending beyond their service as trustee. So why are we so concerned about delivering trust accountings to beneficiaries? Well, the statute of limitations for matters in a trust administration by default is 40 years. If there are matters that have been deemed to be hidden from the trust beneficiary, the statute of limitations period increases to 70 years. If you provide an accounting to the beneficiaries, then for matters adequately disclosed in that accounting, the limitations period is reduced to 4 years. And if there's a limitations notice, which, by the way, this is often overlooked by trustees, but if there is a limitations notice that is provided to the beneficiaries along with the trust accounting, the limitations period is reduced from 4 years to 6 months. And the slide shows you the magic language for the limitation notice that should be included with any trust accounting or trust disclosure document. If you follow these procedures, the limitations period is reduced from 40 years to 6 months.
And Matt, what you're saying is that beneficiaries can waive the requirement of an accounting, and what that does is means the trustee hasn't breached their duties under the statute. So they're not they're not going to be held to be, be removed or have damages for failing to do the accounting once it's waived. But that doesn't help you with the statute of limitations. Only actually doing an accounting and doing the limitation notice will reduce the time period that they can challenge the trust, what the trustee actually did.
Right. And in delivering these accountings, the trustee wants to make sure that they are delivering them to the appropriate parties so that all the interested parties are bound by matters that are adequately disclosed in that accountings. And this also comes up in court actions and obtaining beneficiary consents. So we always want to look at who the interested parties are and whether or not those interested parties can or should be represented by somebody else. And mistakes come up in this context quite frequently with respect to parents representing minor beneficiaries of the trust. Quite often there can be a conflict of interest between the parent's interest in the trust and the minor child's interest in the trust that would preclude the parent from representing the minor child in that matter, and you'd have to look for an alternative form of representation in that case. I think one of the forms of representation that's often overlooked is that a holder of a power of appointment under a trust can represent all the permissible appointees, but also importantly all the takers in default of the exercise of that power of appointment. Okay, so now we're going to quickly move over to some common mistakes that we see in handling IRAs in an estate plan. We often see that there are comprehensive wills and trusts prepared, but the IRA beneficiary designations are an afterthought, or there are wills and trusts prepared and beneficiary designations that simply don't have the appropriate language in there to provide for the extended payout based on the life expectancy of a designated beneficiary, which is generally the objective when planning with these, so that we can defer the income taxes inherent in the IRA for as long as possible. And this is becoming more and more important as we see more clients with a significant part of their assets held in IRAs, and mistakes in this area can cause an acceleration of the income tax consequences in the IRAs. So in order to coordinate these IRAs with our plans, we do customized beneficiary designations that match what we have in our wills and trusts. Simply, the IRA custodians forms are not detailed enough to provide for that. But what we found is that a lot of IRA custodians do not like to receive customized beneficiary designations. And the reason is that they don't want to be responsible for factual determinations required by the beneficiary designation or legal determinations that may be required by the beneficiary designations. So, for example, if our contingent beneficiaries provide for distributions to descendants per stirpes, the custodian doesn't want to have to figure out who descendants are and what per stirpes means. So, what we've done in our beneficiary designations is to try to shift the responsibility for determining who descendants are to the personal representative of the participant's estate or the trustee of his or her revocable trust. And legal determinations, we try to be thorough in our explanation of what those mean within the beneficiary designation itself. But this is extremely important because the IRA beneficiary designation needs to be accepted by the IRA custodian in order for it to be applicable and valid. So a couple of quick points with respect to IRAs that are often missed. In the tax allocation provisions, IRAs are not addressed. And if you had apportionment of taxes to all interests included in the measure of the tax included IRAs, you could have estate taxes apportioned against IRAs. That could cause the beneficiary to have to withdraw funds from the IRA, thereby incurring income taxes in order to pay the estate taxes. Now, the beneficiaries will get a deduction for estate taxes paid against their income tax in that situation, but it's generally better to have the taxes allocated away from qualified plan assets, if at all possible. Another planning point that's often overlooked, and this comes up in the context of leaving IRAs to a spouse. Oftentimes, at least in first marriages, we'll leave IRAs payable to the surviving spouse outright, so the surviving spouse will have the ability to roll over the IRA into his or her own IRA, and that generally provides for the maximum payout period. However, with respect to estate tax planning, we may want to include in the IRA beneficiary designation a disclaimer provision that says if the spouse disclaims any portion of the IRA, then it will be paid to the credit shelter trusts. Now, IRAs are not generally the best asset to use for credit shelter trusts because of their built-in income tax liabilities, but including a disclaimer provision in your beneficiary designation form just provides some good flexibility for planning down the future, and that's often overlooked. So, another mistake that's often made is having IRAs payable outright to beneficiaries. There may be good tax reasons to do so with respect to spouses and the ability to do a rollover, but with respect to children and more remote descendants, we prefer to have these IRA proceeds payable to trusts for creditor protection purposes. There was a recent Supreme Court case, the Clark case, that held that inherited IRAs were not retirement funds within the meaning of the Federal Bankruptcy Code, and therefore they do not enjoy that protection. So if you want to protect these assets for the benefit of your children and more remote descendants, then it is a good idea to leave them in trust for those beneficiaries. When you leave things in trust for beneficiaries, the trust has to qualify as what we refer to as a see-through trust in order to get the extended payout period based on the life expectancy of the beneficiary. Generally, each of the elements are relatively easy to meet, as are shown on the slide above, except that you have to make sure that all of your trust beneficiaries are individuals. And so the mistake here is naming your revocable trust as the primary beneficiary of the IRA. That raises the risk that you have a non-individual beneficiary that could disqualify the trust as a see-through trust. Also, you have then included all the beneficiaries of that trust within the possible life expectancies, which mean you could have a very elderly beneficiary that is then you're measuring life for your life expectancy payout that may apply to, say, young children. So the better approach here is to name the trusts created under your revocable trusts, the separate trusts for the individuals as the beneficiaries of the IRA. And there are two kinds of trusts that we use in this instance. One is called a conduit trust, and the other one is an accumulation trust. A conduit trust simply provides that IRA distributions that are received are paid out to the trust beneficiary. This makes it very easy to identify the trust beneficiary and determine the qualification and the life expectancy payout, because you don't have to look any further than the current trust beneficiary. However, it is not ideal for asset protection because you're required to distribute out the IRA distributions to that beneficiary. An accumulation trust does not require mandatory distributions of the IRA distributions to the beneficiaries, but you can't look solely to the current beneficiary. You have to look to the current and remainder beneficiaries as well as permissible appointees. And so caution must be taken in drafting these kinds of trusts to make sure that it qualifies as a trust and that you have the appropriate measuring life for your expectancy payout. And what we do here is we try to provide that IRA benefits won't be paid to anybody in a generation above the beneficiary, and within the class of people, including that beneficiary, the beneficiary's siblings and descendants, the last living person in that class would be receiving the IRA entirely. And that's kind of the last man standing provision. I'm getting the red light flash over here, so I'm going to pick things up. Okay, 2 quick points with respect to marital trusts. We need to make sure that the spouse gets all the income from the IRA, or at least has a right to withdraw it. Just distributing IRA distributions is not sufficient. And also we need to be careful not to have the IRA satisfy pecuniary, that means fixed amount, gifts. You could accelerate income in that circumstance as well. Quickly on to Homestead. provisions. A couple of quick things here, just to note, mistakes and failures of understanding. I think a lot of people believe that the homestead protection is absolute, but it is not an absolute protection. The federal law preempts state law, so the federal government is not bound by Florida's homestead provisions. Okay, so to the extent that someone doesn't pay their taxes, the IRS can come and levy against the property. In addition, federal bankruptcy laws have certain rules which limit the availability of the homestead exemption. It's if you acquire a homestead within 1,215 days of filing for federal bankruptcy, then the homestead is limited to $125,000, which is a little greater than that now because it's cost of living adjusted. And then there are a few mistakes in the not adhering to the restrictions on the devise of homestead. I think most commonly people will put their homesteads in trusts and then designate a marital trust to receive the homestead for the benefit of the spouse, but they haven't gotten an appropriate homestead waiver from that spouse. So now the spouse then gets a life estate with remainder to the kids. There's an election that the spouse can make also to take a 50% interest. In addition, there are times when the decedent may have gotten a valid homestead waiver from the spouse and believes that homestead devise restrictions don't apply, but they have a minor child, okay? And the homestead restrictions do apply if there is a minor child. So when looking at homestead, you need to consider the ownership of the homestead. If it is jointly owned with a spouse, you take it out from the homestead devise restrictions. There's also a special irrevocable trust that can be used to withdraw the homestead from those special devise restrictions, but those things are often overlooked. Sorry, David, I did run over my
It's okay.
time.
It's Brian that's up last this time, so I feel for him. But that's okay. I may run over too. Anyway, I'm going to cover three topics today. The first is will and trust drafting errors, and the first few examples deal with estate tax apportionment issues, which Matt spoke to just a little bit. And for these examples, these first 3 or 4 examples, I'm going to assume that the estate tax exemption amount is and always has been $5 million, and the top estate tax bracket is 40%, so nobody calls me and says your examples are wrong. It's just easier to make the numbers work, and if you don't take out those variables, it kind of muddies the point I'm trying to make and makes it a little bit more difficult to see it. So one of the things is not specifically taking into account prior gifts that may have used the decedent's exemption amount and prior gift taxes paid, because gift taxes paid within 3 years of death. Gift taxes paid on gifts made within 3 years of death are brought back into the computation of the taxable estate, as are taxable gifts during the decedent's lifetime. Florida law, the default rule under the Florida state tax apportionment statute is that all estate taxes, including the gross up, the estate tax that's due to the gross up on lifetime taxable gifts, and the gift tax paid on gifts within 3 years of death, are paid by the people who receive the decedent's assets at death, not the recipients of the gifts. And so you may have had one person receive a gift and receive the benefit of the estate tax, unified estate and gift tax exemption, and somebody else receive the assets at death. And I've got an example here. We have William Sr. He's a widower. He has a son, William Jr., and a daughter, Wilhelmina. We'll call her Willie for short. And in 2011, Sr. had a business worth $10 million that Jr. was involved in. He had other assets with a fair market value of $22 million for total assets of $32 million. Willie was not involved in the business. Now, Bill had heard that it was a good idea to make gifts during life to move these assets out of his estate, because all future appreciation after the time he made the gift would be transferred to, and it wouldn't be subject to tax at his death. This thing was green all the time I was doing it for Matt. Now it's red. I don't know what that means. So anyway, he made a $5 million gift in 2011, used his entire estate tax exemption that even though it was only 3.5 in that year, And in 2014, he gave the other 50% of the business, also worth $5 million, to Junior. So he's made a total of $10 million and paid gift tax in 2014. So he's given away $10 million of his 32. He's paid $2 million of gift tax. So he's reduced his estate by $12 million, down to $20 million. He then dies in 2015. He has a gross estate of $20 million. He has $10 million of lifetime gifts, and he has gift tax paid in 2014, which is obviously on a gift within 3 years of death. If you work down through there, it comes out to an estate tax of $8,800,000, and I can't tell you how difficult it was to get a number that was divisible by 4, which is important to my example. So Junior and Willie's shares of Senior's estate are determined the correct way. You take the $20 million in the estate, you add back the lifetime gift of 10 to come up to 30, you divide that by 2. Willie and Junior, you come up with $15 million. You subtract $10 million that Junior already got, so he gets $5 million, or 25% of Senior's estate. Willie gets the other 75%. That's okay. What's not okay is the estate tax apportionment in Senior's document, because it apportions the estate tax in proportion to the assets received from the residue of his estate. So Junior receives 25% of the estate, 25% of the estate tax is apportioned to him. He receives a net amount of $2.8 million. He's already received 10, so he receives a total benefit from his father of $12.8 million. Willie receives 75% of Senior's estate, but also bears 75% of the estate tax. She receives $8.4 million. That's a difference of $4.4 million, not what their father had in mind. In a situation like this, you should allocate the estate tax based on the total benefit, and that's easier said than actually done in terms of drafting a provision that would do that. And you run into complications like, do you take into account appreciation of the assets that have been given away and such? But the result should be that both Junior and Willie end up at the end of the day with half of the assets that were available, not including the gift tax, which is just gone. So they should each end up with about $10.6 million if the estate tax were apportioned in this manner, half of it to each of them, because they each received half the benefit of Senior's estate. What about an estate tax apportionment clause that says you ought to pay all estate taxes that are due, even on assets passing outside the will and the revocable trust, from, let's say, the residue of the revocable trust? Well, the decedent may have had other assets. Let's take Oscar Madison and Felix Unger. So some of you may have heard of them before. They were kind of an odd couple. Oscar had been married. His wife had died, left him a widow. He had some children from that marriage. And in 1964, Neil Simon tells us, he and Felix became roommates and lived together the rest of their lives. So Oscar says to Felix his entire life, Felix, I don't have a wife, I don't have any minor children, my children are all adults, I can leave you my homestead, it's not devise restricted, and I'm going to leave you all the assets in my revocable trust, which will be enough with your pension to keep up the house and live comfortably. Felix feels fine about that. Oscar dies. The other assets Oscar has are an IRA, he's designated his children as the beneficiaries, life insurance, he's designated his children beneficiaries, and joint accounts that he has with his children with right of survivorship. All those pass by operation of law to his children. He has a total estate of $11,667,000. The estate tax is $2,667,000. His document says pay all that from the residue. Whoops, that wipes out the revocable trust. Felix only gets the house, and he doesn't have enough money to pay the taxes, the insurance, and keep the lights on. Not what Oscar intended. What we should have done, Matt touched on this, what they should have done was to allocate the estate tax proportionately to all the assets, except as Matt mentioned, they probably should have paid would have wanted to pay the estate tax attributable to the IRA from another asset. Because if you pay the estate tax from the IRA, you trigger income tax. If the child doesn't have any other sources but the IRA to pay the income tax, he has to take the income tax out. It's a circular calculation that ends up eating up a third or more of the IRA. What about mandatory distributions from trust? I don't think we've ever done a seminar where we haven't talked about this. There's kind of a continuum of options on distributions from trusts, so let's say for children. When I started practicing years ago, kind of the standard thing was mandatory distributions of trust shares at selected ages, 25, 30, 35. What's the problem with that? Well, if you have a creditor who has a writ of garnishment against the trust for a debt owed by the beneficiary, then as soon as that distribution becomes payable, it has to be paid to the creditor. What about a power of a beneficiary to withdraw assets at 25, 30, 35? Well, you still have the same creditor problem as soon as the right of withdrawal arises. The only possible benefit is if the child leaves it in there, it stays segregated from his marital assets in the event of a dissolution of marriage. Moving along the continuum to the third point there, you don't have any mandatory distribution provisions either, and so everything, it's going to be a lifetime. It's going to be a dynasty trust, but you allow the beneficiary, the child, to become a trustee or a co-trustee at some point. That's almost like owning the assets yourself. It's just another account that they're held in, and you can determine how much you need. Now, Florida law provides protection in that instance, except for certain exception creditors, alimony, child support, and maybe the federal government super creditors like the SEC, FCC. And it's clear now under the Berlinger case that a former spouse who has a deficiency for alimony can reach that trust. But what about, let's say the child then who's the beneficiary and sole trustee moves to another state. So you've got the beneficiary in another state, the trustee in another state, all the assets are moved to another state. The beneficiary has a creditor in that state. It's very possible that the laws of that state are not as favorable as those of Florida regarding creditors, and that a state court in that jurisdiction, that state, might decide that the trust wasn't governed by Florida law anymore. The final continuum would be having no mandatory distributions and having a third-party independent trustee. Still have the same creditor concerns, though. Now that's talking about mandatory distributions of principal. What about just mandatory and annual distributions? You have a provision that says the trustee shall distribute all income to the beneficiary annually and may distribute principal for health, education, maintenance, and support. That's required for a marital trust to qualify for the estate tax marital deduction. It's not really required in any other trusts. So you ought to make all the distributions discretionary on an ongoing basis. Why? Well, first, creditor protection. Second, just to protect the beneficiary from himself or herself. They may not run up any creditors, but they may spend every dime that's distributed to them. It allows the trustee, Matt talked about the duties the trustee has to the beneficiary. The trustee has to treat the current beneficiaries and the remainder or future beneficiaries has equally, or has to give equal weight to considerations of providing for both. If you provide that the trustee can invest for the greatest overall return, then he doesn't have to worry about how much income he produces or how much capital appreciation. It also allows the trustee to control the timing and amount of distributions in order to try to minimize the overall income tax liability of the trust and the beneficiaries. What about not taking into account changes in the applicable exclusion amount or the unified credit? So we've now moved from my make-believe exemption amount into the world of reality. Let's say that we had an estate plan done 10 years ago when a widower with 2 children from his first marriage married his second wife. He had a gross estate of $7.5 million, and he had a optimal marital formula which says that you only give the marital trust the amount necessary to reduce the estate taxes to zero, taking into account the unified credit. Well, that would have meant $1.5 million exemption. $1.5 million would have gone into the children's trusts, and these children, he's already made significant gifts to them during their lives. They're already, he feels like $1.5 million is enough for them, and $6 million or 80% of his estate at that time would go to his wife. Well, the happy couple takes off and travels the world for 10 years. In 2015, husband dies. His gross estate's the same because they've spent all the income and appreciation on their travels. But the exclusion amount is now $5,430,000. That means the children's trust gets that amount, nearly 70% of his estate, and his spouse only gets a little less than 30%. What about not taking into account portability and basis step-up? I know we've touched on this at most of our seminars. Say you have somebody that dies this year, they have an amount exactly, their gross estate exactly equal to the exemption amount, $5,430,000. Those assets receive a step up to fair market value. And let's assume that over the next 10 years, they grow at an average rate of 10%. The second spouse dies in 2025. So you compare what happens, what the difference in the result is between a traditional optimal marital deduction and just giving everything to the marital trust. In the left-hand column for you, the credit shelter trust, in 10 years, there's almost $7.3 million of assets in there, but the basis is the same. Let's assume no asset was ever sold or purchased, so the basis is still the same. It's not included in the spouse's gross estate. It doesn't get a step up in basis. The children then sell all the assets the next day, and they owe almost $400,000 of capital gains tax. Not the optimal result. Let's say you left instead, he had changed his estate plan to leave everything to a marital trust, and they had made at his death the election to carry his unused exemption amount over to his surviving spouse. So she has a combined more than $10 million of exemption. It's $7.3 million in the marital trust and included in her estate at her death. So all of it stepped up to fair market value basis. There's no estate tax because she has her exemption amount plus his. The children sell the asset the next day, no income tax. What about not taking into account changes in circumstances? Some of those might be marriage, divorce, birth, adoption, death of beneficiaries, acquiring or selling a business, or just a change in your relationship with a fiduciary. You know, maybe your college roommate was a top hotshot broker in Wall Street. One day you pick up the paper and you find out he's been arrested for stealing millions of dollars of his client's assets. Maybe not the best choice as your fiduciary. One thing that I see clients overlook a lot is when a child attains the age of 18, he or she may need his own estate planning documents, especially a designation of a healthcare surrogate, because once your child is an adult, you can no longer make healthcare decisions for them. All right, let's delve more deeply, and I'm in the home stretch here, into a couple of these changes in circumstances. First, failing to update your estate planning for marriage. First, you ought to have a prenuptial agreement, I guess, unless, of course, your person you're marrying is much wealthier than you may not want one. You ought to change your will and your irrevocable trust because your new spouse is going to have certain rights under Florida law, either as a pretermitted spouse or they could elect the elective share, which Lauren talked about, and they'd probably choose one of those, one of those that left them in the best situation because they're computed differently. You ought to change beneficiary designations. And what the client needs to do, and what you need to talk to them about, is they need to balance the interests of their new spouse with their current children, if any, from prior marriage or marriages, and any stepchildren. What about failing to update documents after a divorce? Florida law helps clients who don't get around to making changes because there are several statutes that basically takes the spouse out or former spouse out or revokes the powers that he or she had under a will, a revocable trust, a durable power of attorney, or a designation of a healthcare surrogate. Now, all of those are effective upon the dissolution of the marriage, which is when the order of dissolution is entered, except the one that revokes or terminates the powers of the wife as an agent under a durable power of attorney. That's terminated on the filing of an action for dissolution of marriage. And the thing is that a third party can rely on that durable power of attorney. So if you have an unscrupulous spouse, he or she could still go around and take assets out of accounts until the third party had notice. But there are other reasons you may, even though Florida statutes are going to help you or your clients to the extent that they don't take action, you may no longer own assets after your divorce that you owned before. Some of the assets you own jointly with your spouse, you may own individually, and so they no longer pass by operation of law. You need to provide for them in your documents. You may need to rethink your entire estate plan because you've lost the marital deduction. And finally, you need to look and see if you've named any of your former spouse's relatives as fiduciaries. You need to, as I said, same as with marriage, you need to change beneficiary designations, which people should review. They may periodically in any event, and change the ownership of joint accounts. Now, again, Florida law provides some help. It says that a designation of a spouse, a former spouse, is void at the time the marriage is judicially dissolved, and the interest passes as though the former spouse predeceased. That's been around since 2012. That applies to life insurance, annuities, employee benefit plans with an asterisk I'll explain in a minute, pay on death deposit accounts with the former spouse, securities registered as a transfer on death account with the former spouse. But it does not apply to the extent federal law provides otherwise, and ERISA preempts state law to the extent ERISA covered plans, that's a federal law, provides otherwise. I'll let you read there's some other exemptions that this statute doesn't apply to, but what is ERISA? It's a federal law that covers certain types of retirement plans, and it says that no state law can override or control the administration of a plan that's governed by ERISA. Plans covered by ERISA include traditional pension plans and defined contribution plans, such as 401k plans, 403b plans, ESOPs, and other things. And I hope I didn't eat into too much of Brian's time.
Okay, well, my partners have generally left me about 10 minutes, so I'm going to cut down my portion, and it's a good time. It reminds me that one of the estate planning mistakes we left out was that never agree to go last in a presentation with 3 other people. So forgive me for rushing through some of this, but I just want to highlight some issues. I think that says 5 minutes, but okay.
But we really have 10.
Yeah,
We have 10
I'll
minutes.
cut it down to 10. All right, so first of all, number 10, inadvertent terminations of S elections due to impermissible shareholders. And from a show of hands from everybody that's awake, how many are familiar with S corporations and the restrictions on ownership? Okay, so that's a good thing. I can skip a lot of the background. But basically what you have is a lot of people will form corporations and make a election under subchapter S of the code to be taxed as an S corporation, because what that does is it allows you to avoid the double layer of tax that's generally imposed on C corporations. So if you have an S corporation, you're just taxed at the shareholder level, and to the extent earnings are distributed out in later years, you're not subject to another dividend tax, usually, to the extent you have basis. Well, to get the benefit of that S election, you have to meet certain restrictions, and one of those is the ownership of the shares. You can only have a certain number of shareholders, but the shareholders can also only be individuals, exempt organizations, estates, or trusts, certain types of trusts. And where I'm going to focus my time on mostly is on the trust, because that's where we see the most frequent errors. If a S corporation does acquire a shareholder that's not a permitted shareholder, and of course that acquisition is unintentional, then you run into the situation where you have an inadvertent termination. So that's what I'm talking about. It's where the S corporation has lost its S election because it's acquired a non-permitted shareholder. And the consequences can be pretty severe depending on when you discover the error, because generally it's years later, you don't remember or you don't recall that the termination happened, because obviously it was inadvertent. And then you have years where the corporation was taxed as a C corporation instead of an S corporation. So you have back taxes owed, penalties, interest, and of course professional fees to fix it. So just to run through a couple of examples on here to give you an idea of some of the errors we see. The first one is the situation where a parent makes a gift of S stock to an irrevocable trust for child. So the question is that irrevocable trust a permitted shareholder? Well, what it comes down to is a decision of whether it's a grantor trust or a non-grantor trust. And by grantor trust, we mean, is the person that's contributing the stock to the trust the one that's legally obligated to pay the income tax on the trust, income and gains? And if it is a grantor trust, you're good to go. An election is not necessary. If you're in a situation where it's not a grantor trust, you have to make a QSST election, a qualified subchapter S trust election within 2 months and 16 days after acquiring the stock, or an electing small business trust election depending on the terms of the trust within that same time frame. So if you make the gift of the stock, an election is not made and it's not a grantor trust, you run into a situation where your S election is terminated after that 2 month and 16-day period has passed. Taking example 2 now, the situation where an individual owns stock until their death, and then at their death, under the terms of their will, it says, I'm going to give all my stock to a trust for the benefit of child. Well, during the shareholder's lifetime, they're an individual, they're a permitted shareholder. During the estate administration period, the estate is a permitted shareholder. Once the stock is transferred out from the estate to the trust for the child, that's when your time clock starts running. And so there is an exception under the rules for a testamentary trust. And so for a trust that's created under a will, they will be a permitted shareholder for 2 years from the period they acquire the stock. It's at the end of that 2-year period where we see mistakes made, where you have to make, at that point, an election whether it's a QSST election or an ESBT election, to have the trust continue to be a permitted shareholder. And that election has to be made within 2 months and 16 days after the expiration of that 2-year grace period. So sometimes we'll see that that subsequent ESBT or QSST election is not made. Dealing with the Rev Trust situation, first taking the aspect of during somebody's lifetime. Person, settlor, contributes their stock to their revocable trust. That's an easy one. Revocable trust is a grantor trust. It's a qualified shareholder because it is a grantor trust for income tax purposes. So what happens upon death is when your time clock starts running again. The general rule is that you have 2 years from the date of the grantor's death where that trust will continue to be a permitted shareholder. But that can be extended in some circumstances. There's an election under 645 of the code that says you can elect during the revocable trust administration period to treat the revocable trust as part of the estate for income tax purposes. If you do that, your grace period for continuing to be a permitted shareholder continues up until generally 1 year after you get the estate tax closing letter back from the IRS. So just pointing out the example that's on there, let's just say your grantor has too much fun on New Year's Eve. He dies January 1st, 2016. Estate tax closing letter is issued 18 months later on June 1st, 2017, which is probably in the ballpark area of when these things generally get issued. And you had a 645 election made. Your trust is a permitted shareholder until May 31st, 2018. So you have more than 2 years in that situation. It's at the expiration of that 2-year period that you need to be mindful that you need to have a permitted shareholder after that. And so what you run into the situation is if you have a continuing trust for the benefit of a child and a 645 election, you get an additional 2 years under the testamentary trust exception. If you did not have a 645 election in place, let's just say it was a revocable trust, once that child's trust acquires the stock, they have that 2-month and 16-day period. So there's all these different time periods to keep track of. A lot of times these deadlines are missed for filing these QSST or electing small business trust elections. And so the question is, a lot of times you say, well, how do we fix it? And there's PLRs being issued all the time. There's really 2 general avenues to go. And the first one to look at is the Revenue Procedure 2013-30. This is kind of the expedited relief process. It says as long as you meet these certain requirements that are in there, then we're going to go ahead and automatically give you relief and grant, basically overturn the termination of your S election. One of the requirements for that has to be within 3 years and 75 days, basically, of the time when the termination occurred. So if you're outside that window, then you're writing a PLR, private letter ruling request to the IRS to ask for forgiveness. And, the only people that are going to be happy about doing a PLR request are the advisors that you're paying to do this for you. Nobody likes to ask for forgiveness. It's kind of like asking your spouse. You don't really want to do it, but you know you have to, and at the end of the day, it's going to cost you a lot of money to get out of trouble. So people don't really want to go down that route. Just focus the rest of my time on the generation skipping transfer tax issues. There's a lot under here. For those of you that are familiar with generation skipping transfer tax, there's pitfalls everywhere, and I'll just point out a few of the ones that are highlights. For those of you that aren't familiar with the GST tax, basically it's an additional layer of tax on top of the estate tax and the gift tax. So you can have a transfer made at death that's subject to estate tax, and if it's also a generation skipping transfer, it can be subject to another GST tax. GST tax rate is equal to the top estate tax rate, which is 40%. Simplest example of a generation skipping transfer, I make a transfer to my grandchild, so I've skipped my child's generation. In that situation, that's a GST transfer that could be subject to tax. The other 2 types of generation skipping transfers, taxable distributions, taxable terminations, those are really where you have transfers in trust, and then at a later date, there'll be a transfer to a skip person where the GST event is actually sometime in the future when that transfer comes from the trust. Looking at the first issue, this is a pretty common mistake we see, is the allocation of GST exemption when there's crummy withdrawal rights involved. And so just taking the most common example we see, parent sets up an insurance trust for their child. They give their child and grandchild maybe a crummy right of withdrawal, the right to withdraw up to $14,000 per year of every contribution. And the purpose of that withdrawal right is to qualify the transfer for the annual exclusion under the gift tax. So you don't use any gift tax exemption. So a parent makes a transfer to trust, $28,000. The trust will use that money to pay the premiums. Each child, or the child and grandchild, will have a right to withdraw $14,000 from the trust. So the question is, do you need to allocate GST exemption to that? And of course, the lawyerly response is, well, it depends. The question is, if you want the trust to be exempt from GST tax, meaning that future distributions to grandchildren or remote descendants will be not, if you want that not to be subject to GST tax, then you don't need to allocate GST exemption to either the child's withdrawal right or the grandchild's withdrawal right. A lot of times we'll see people allocate GST exemption to the grandchild's withdrawal right because the grandchild is a skip person. The general concept to keep in mind is that you allocate GST exemption to the trust based on whether you want the trust to be exempt, not based on who has the crummy withdrawal right. So in this situation, if you wanted the trust to be exempt from GST tax so that future distributions to skip people are not subject to GST tax, then you have to allocate GST exemption to the grandchild's withdrawal right and also to the child's withdrawal right. So sometimes we'll see where GST exemption is not allocated to the child's withdrawal right because the person is thinking that, well, they're not a skip person, so I don't need to allocate it. But that's not the case. The other big issue, and this is...
Go ahead. Yes, Chemo. I'm sorry.
Yes.
I say that again. Is there's $28,000 of gifts made?
Yes, if you want the trust to be exempt, you have to cover the whole amount of the contribution from exemption. Mm-hmm.
If I understood you correctly, you said that you have to allocate to that grandchild, which I understand, what was the allocation of $14,000, which is the amount of or would you actually have to double up in that?
Okay. You're not allocating to the grandchild, by the way. You're allocating to the trust. That's the biggest problem that I see everybody make. They misunderstand that with a gift tax, when you make a gift to a trust, for gift tax purposes, you're actually making a gift to the beneficiary of the trust, okay? But for generation skipping tax purposes, the gift is to the trust itself. So if you made a gift of $28,000 to that trust that you want to be generation skipping tax exempt in the future, you must allocate $28,000 to the trust. If you only gave $14,000, you would allocate $14,000. If you didn't want that trust to be generation skipping exempt in the future, you would allocate zero.
Then on your gift tax return, you have two separate gifts listed, one to the parent for $14,000 annual exclusion, and the second, and I guess it's section C of the gift tax exclusion, $14,000 allocated to the trust for the benefit of the grandchild.
Well, the way we do it is the gift up front is going to determine where it goes on the gift tax return. If it's a trust that is an indirect skip, meaning it's a GST trust in this situation, that goes on part 3. We typically list it as a gift to the trust with noting below that the child and grandchild had withdrawal rights of $14,000 apiece, and then we'll show an allocation of GST exemption on the last, I think it's
Of $28,000.
Schedule D now. Yeah, of $28,000.
So you actually specify on the gift tax return itself, if the trust so indicates that it's for Chemo Hyatt, a grandchild, you specified it as a GST trust, that Chemo Hyatt has the withdrawal rights of that trust. And you make
Right.
the reduction of the credit on, I guess it's page 4 or 5.
Right. Yeah, if we're trying to claim the annual exclusion for that gift to the trust, then yes, we designate who had the crummy withdrawal right. Okay, so real quickly, running over the missing the allocation, the automatic GST allocation rules. This is something where this is the most frequent error I see in when reviewing gifts to trusts. Basically, what happened is prior to 2001, there were individuals who would make transfers to trusts and forget to allocate GST exemption where it should have been allocated. So Congress came in to save the day like they always do, right? Okay, never mind. But in 2001, they enacted 2632C, which says, for gifts made to trusts which could have a generations giving transfer in the future, we're going to go ahead and automatically allocate the donor's gift tax exemption to the extent necessary to make it a zero, basically to make it completely exempt from GST tax. And it's subject to a list of exceptions, which I won't go into, but they're under there. But basically what you'll have is, it's now that the automatic allocation rules are in effect, grantors will make gifts to trusts not knowing that the automatic allocation rules will apply. So you'll run into a situation where somebody may have made, annual exclusion gifts to the insurance trust, just going back to that example. They have $28,000, there's 2 crummy beneficiaries, so the gift is completely covered by the annual exclusions, which means a gift tax return is not necessarily required. But that gift will still have used GST exemption. So at the end of the day, we're in the situation where we're trying to figure out exactly how much GST exemption a donor has used, where there may not be a paper trail of gift tax returns that show everything. Because at the end of the day, the GST exemption really helps us plan when we're coming up with gift ideas or even structuring revocable trusts and gifts under that.
Or at death, that you've got whatever the remaining GST exemption is goes into an exempt trust and everything else goes into a non-exempt trust. You need to know how much your exemption is. And unfortunately, when you've made gifts to trusts and you haven't done gift tax returns, or even if you've done them and you haven't necessarily done them correctly, you have to figure out how much of the GST exemption was automatically allocated. Okay? And it's not fun to go back 10 or 15 years to try and figure out what was the premiums that were actually contributed to that trust. Right. It's better to do it every year and keep track of it.
All right, just skipping ahead to the very last slide, last problem, administering a trust with a mixed inclusion ratio. And by this, what we mean is you have a trust where GST exemption has been allocated contributions to the trust, but not enough allocation has been not enough exemption has been allocated where it's a zero inclusion ratio and the trust is completely exempt from GST tax. So the reason that this is an issue is because you could run into the situation where generations giving transfer tax is being paid when it doesn't need to be paid, and nobody likes paying the IRS just out of the mere kindness of their heart. So what we do in this situation is, just looking at the example, let's just assume a $2 million gift is made to the trust and the donor only has $1 million left of GST exemption to allocate to it. So at that situation, you have a trust that's half subject to GST tax and half that's exempt from GST tax. So you have a inclusion ratio of 0.5 or 50%. If you make transfers from that trust to the child, it's not a GST transfer. You don't have any GST tax. But if you make transfers from that trust to the grandchild, you're basically going to pay GST tax at 50% of the GST tax rate, which would be a 20% tax. So what you could have done instead is split up the trust up front, do a qualified severance. So you have one trust that's completely exempt, one trust that's completely non-exempt. There'd be $1 million apiece in this example. Transfers from the trust to the child would be made from the non-exempt portion so that you're not paying a GST tax. Transfers to the grandchild would be made from the exempt portion so that you're not paying a GST tax. What it works out to be is if you distributed about $1 million to the grandchild out of this trust, you're saving $200,000 in GST tax. So that's something that can easily be done, saves a lot of tax for the clients, which hopefully will make them happy. Yes. Oh, David just raised the issue. You can sever a trust anytime you want to. Or it can be in existence for 20 years. You can sever it whenever you want to. There's just certain rules that you have to follow. So with that, I guess I'll end it there. Is there any questions or anything like that? Tom?
How cooperative are you finding the plan administrators to work when you're working with one as beneficiary designation?
Not at all.
Not very.
Zero.
Everywhere I go, it's like, oh, we use great language, and I have that, and I'm back and forth, and back and forth. And finally, I have to say, you move your money to these people, and they'll work with you, or I don't.
It in large part depends on the size of the IRA. I found people with very large IRAs get more cooperation.
It's true, but I mean, because you will run into, you know, IRA custodians that'll say, here is, you know, you have this choice. You can give it, you can have 3 boxes to check, you can't do anything else. And we're like, we don't want it to go to those 3 boxes. Okay?
Please
And
don't forget.
and you have to move it.
Please don't forget to fill out and turn in your evaluations.
Yes, please.
Why don't,
Turn
if
in
anybody
those
has questions,
forms.
why don't you come up? We'll wait here a few minutes, and
And
anybody
answer
who
questions,
needs to leave can
and
go ahead and leave.
everybody else doesn't have to stay, but fill out your evaluation forms, please.
Problems with it. The trust